I'm Jeffrey Sprigg, one of the senior partners here at the Sprigg-Novak law firm. One of the questions we often receive is, what is a retainer? Well, a retainer is a payment that is made to your attorneys to get you started on your litigation journey. One of the best analogies would be it's like a gas tank. You're putting fuel in your tank in order to bring you along on this trip that will take you hopefully to a good result in court. Under Texas law, attorneys are required to have what is called an interest on legal trust account, or an IOLTA. This account is set up and attorneys have to report that to the state of Texas. And the interest from this account goes to the state of Texas to help support the Texas Equal Access to Justice Fund. That provides services to indigent individuals who simply can't afford legal representation, for example. The money that's in the IOLTA is your money, and it remains your money until such time as we do work to bill against it. So when we do our work, say we spend an hour drafting pleadings, we will then deduct the equivalent of 1 hour's work based on our billable rates from your retainer. Now, at the end of a matter, if there's money that's left over in your retainer, then that is refunded back to you. But during the course of the litigation, if things become complex or they are delayed because of the court not making rulings, or the other side is filing a lot of paperwork that we have to respond to, then your gas tank might become drained more quickly, and that would require a refresh of your retainer. Now, when we do our cases and when we ask for your attorney's fees as part of a judgment, we will always ask to be fully reimbursed for the funds that you've paid to us as part of your retainer. Under Texas law, it is the trial judge's discretion as to how much attorney's fees can be given in a case, assuming that those fees are recoverable. So it is possible that a judge has a bad day or is simply not in the mood to award a full amount of attorney's fees, and they can reduce your fees. However, if you are the prevailing party and attorney's fees are recoverable for the type of case that you're in, the court cannot simply zero you out and say, well, that's too bad, you don't get any attorney's fees. That is not proper under Texas law, and that might be the basis for an appeal. If you have additional questions, please feel free to reach out to us.